Parents of a young girl who was sexually abused by a former CMS tutor can proceed with their lawsuit against the school district. This comes after an appeals court ruled CMS can't claim immunity in the case. Police arrested Ricardo Mata back in 2019 after he was accused of sexually assaulting young girls. Mata ran an after-school Spanish language program called Play Spanish at several CMS schools. He later took an offered plea, which allows a person to still maintain their innocence while acknowledging it's in their best interest to plead guilty. One of the victims' families later sued the school district and 3 employees. School officials claimed, though, that they were shielded by governmental immunity. A state appeals court disagreed just last week, meaning that the case can now move forward. All right, we've got our chief legal analyst, Khalif Rhodes, in with this case. 2019, we know justice sometimes takes a long time. He took the offered plea. Are you surprised that the court said CMS and the employees, sorry, immunity thing's not going to work here?
I mean, 99% of the time when you're in these situations, what the CMS said and the defendant said is that, or the 3 individuals said is that, yes, I am immune in my individual capacity as the teachers, because I'm a teacher, and I would have some ability to grab some of that immunity that the school would have. And the school, you want to put them in a position as well that because they have these immunity protections, you can't bring a claim against them. So that's the original argument. District court judge agreed with that argument. You appealed it to the Court of Appeals, and the Court of Appeals walked through the argument and said, well, this playtime thing that CMS was running was more like a private business. It wasn't, and it didn't fall under the immunity that you'd have for some type of public institution. And they said for the 3 folks that you weren't in your individual capacity as employees of CMS at the time, that you were in some other employment status, and because of those things, because it was a business and you weren't under your employment status as a CMS employee, then yeah, this can go forward with both CMS and the 3 individuals. So I'm not surprised when you look at the arguments that they unfolded. This is good lawyering by plaintiffs. First of all, you don't get the decision that you'd like in district court. I mention this all the time. You don't complain, you don't get frustrated, you don't throw your hands up in the sky. You thank the court for their time and you appeal. That's what they've done, and the Court of Appeals believe that this is a case that's allowed to get through the front door. And I got to be clear, it's hard to get through the front door in the United States District Court. For you to be able to file a claim, you got to make sure that you have standing, that you have an injury in fact, and that you can get around any immunity, those force fields that are there to protect these institutions. So that is excellent job lawyering by their team.
Part of this lawsuit, Khalif, said that CMS had records on Mata, this man, since 2013, but basically sat on the information, kept quiet about that. How does prior knowledge of something like this, how does that affect legal responsibility?
Less to the fact of can our case go forward, more to the fact of will I be successful once we get to trial.
Okay.
So that portion is something that I'll lay out to say, well, you knew or should have known this was preventable, this was foreseeable. You have a duty to prevent foreseeable incidents from occurring. So I'm going to point to the fact that, hey, you guys knew that this was occurring. I mean, the closest connection that I could point to, and as a Penn State grad, I have to go there, but to the Sandusky situation that we had at Penn State, when you point to them saying you are culpable for the things that occurred, not just on the criminal side, but on the civil side. Well, how do we know? Well, because you knew that this was happening for 20, 30 years, did nothing about it, and then more folks were injured and harmed during that time. Well, if we're looking right back at this situation, it's the exact same thing. You knew that this was occurring. Someone else got hurt after the time that you knew this was occurring. That's a clear trial tactic that they'll put out there. And you want to bring those things up when you're presenting it in front of the Court of Appeals. Why? Because now they can see your case. Sometimes you don't want the other side to see your case, but sometimes you do. In this situation, now you know that you're going to be toast when we go to trial because you have this information. All right. Are you closer to settling down, or do you want to actually put this in front of a jury and let them hear the fact that you knew this occurred and you could have stopped this?
Khalif, now the case has a green light. All right, it's going to go forward if CMS is found liable. What does that mean for the family? I mean, is this millions, or like what can you get out of this?
It's hard to put a number on that. It really just depends on first what they're asking for. And you got to remember, it's always a negotiation. So you come to this point because CMS maybe failed to come to the table, or maybe offered you some low ball type of offer, or just said, you know what, we don't believe that you have the finances to take this all the way to trial. And so when you're deciding on that in that room, you're looking at the facts, but then you're also looking at can they take this all the way to trial? Ultimately, they had the means, the resource to take it to the United States District Court, to take it to the Court of Appeals, and ultimately will get their day in court. So now you come back to the table and you're saying, all right, is it in our best interest to keep trying to fight this financially, or do we give them some type of payment? But now on the other side is saying, okay, we've already spent a lot of resources. Whatever number we were asking before is probably triple now, and that's what that negotiation will look like. Now the leverage is on the family side, where before that immunity was protected CMS, and they stood behind that. So those negotiations were probably extremely contentious. Now I bet they'll be a lot more friendly.
Yeah, I can imagine it is. All right, Khalid, thank you very much. Appreciate that.
Queen City News Plus. Just search Queen City News on your smart TV's app store.